Hello, everyone. My name is Jason Cornell. I'm a disability lawyer with the law firm of Liggio and Cornell, and we're located in West Palm Beach, Florida. We handle disability claims throughout the United States, and today I just wanted to talk to you briefly about the duties or obligations that your disability insurer owes you, the plan beneficiary or the employee who's seeking benefits under the plan. A disability plan is a contract. That means there are obligations for both the employee as well as the insurer. And so one of the obligations of you, the employee, as the beneficiary, is to complete an application, submit it to the insurer for their review. You also have a duty to cooperate with your insurer as they're investigating the claim. But since the insurance policy is a contract, that means there's obligations on both sides. And so your insurer has certain obligations that are owed to you. Some of these obligations come under the policy. Some of these obligations come under the federal statute, ERISA, and the regulations that enforce ERISA. One of the most significant obligations that your disability insurer owes you is its fiduciary duty to you. That means it owes you a duty of loyalty. And a duty of loyalty means they have to avoid conflicts of interest and put your interest first when administering the claim. But don't be confused. Just because they owe you a duty of loyalty doesn't mean they're obligated to approve every claim that crosses their desk. Instead, these are duties that the court will look at if they deny your claim and you file a lawsuit for benefits. And the court's going to look and see, have they satisfied their fiduciary duty to you and their duty of loyalty? And by a duty of loyalty, that means they have to avoid conflicts of interest. That means when the insurer is administering the claim, it has to put your interest ahead of the interest of the insurer. So let's just talk about what that looks like for a moment. To satisfy its fiduciary duties, the insurer has to follow the terms of the plan to start with. So the policy is of utmost importance. It also has to avoid any conflicts of interest. Now, sometimes conflicts of interest are inherent, and courts will allow insurers to have certain conflicts of interest, meaning when it has internal reviewers who are employees of the insurance company reviewing claims and deciding whether their employer is going to pay benefits or not. Those are sort of inherent in the system, but courts remain mindful of that conflict of interest nonetheless. Now, when the court is reviewing a denial by a disability insurer, so say you file a claim, they deny it, you file an internal appeal, they deny it again, and then you file a lawsuit with the court. Now you're in front of a federal judge and you're proceeding under the ERISA statute. There, the court's going to look and see, did the insurer abuse its discretion? Because under ERISA, the plan administrator or the insurer is given a pretty high level of deference to its decisions. So courts are going to look and see if the insurer abused its discretion when denying your claim for benefits. And there's different things courts can look at and that you want the court to look at to see if in fact they've abused their discretion, because you'd like the court to overrule or the decision by the insurer and find that you are entitled to benefits. So one of the things the court's going to look at is, what does the language of the policy say? And did the insurer follow the language of the policy? So courts often start with looking at, how does the policy define disability and whether the employee is able to work or not and receive benefits? Another thing courts will look at is, what is the goal or purpose of the disability plan to start with? Courts will also look at the adequacy of the information that was provided by the insurer to its insured, meaning you get letters from your insured, and the disability insurer or the plan administrator is obligated to provide certain information to you so you stay informed about your rights when bringing a claim and your rights under the policy. The court's then going to look and see, did the insurer properly interpret the plan provisions in making its decision? Also, and this is very important, the court's going to look to see, did the insurer make a reasoned engage in a reasoned decision-making process? And here's an example of that. Say your disability insurer takes your medical records and sends it to a doctor that it's hired to review your medical records, and that doctor never sees you, just does a paper review, but then say you're seen by your treating doctor who believes that you are seriously impaired and unable to do the duties of your work, but instead of giving appropriate weight to the decision of your treating physician, if a disability insurer instead focuses too heavily or gives too much weight to the reviewing doctors that it hired, that might be a basis for the court to find there's an abuse of discretion and reverse the decision. Finally, the court's going to look at whether the actions of the disability insurer are consistent with the principles of ERISA. And this is really just a catch-all from what we've talked about as far as the fiduciary duties, avoiding conflicts of interest, making sure that the interest of the employee are put first, and that the interpretation of the plan is done reasonably and appropriate. So those are just some of the things to consider when you're wondering what are the obligations that my insurer owes me, the employee who's seeking disability benefits. If they fail to satisfy those obligations, that could be a basis for a court to overturn their claim denial and award you benefits. So I hope this was helpful. Thanks for being here today. If you ever have any questions regarding your disability claim, give us a call. We'll be happy to speak with you no matter where you are and see if we can provide any assistance. All right, take care, everyone.